support groups in Thunder Bay and Sault Ste. Marie and Manitoulin Island, Timmins and Kirkland Lake and Sudbury, um, Huntsville, Parry Sound, Haliburton, Bracebridge, lots of locations. So this is another in our series of webinars for care partners. Specifically, the topics have been chosen as ones that are of particular interest for the spouse or family member who is caring for someone with Parkinson's. And we are very grateful to the J.P. Bickle Foundation for some funding to make this possible. And if you remember seeing my face last month, you'll notice that my bangs are a little bit shaggier than than last time because I'm holding out for our cut-a-thon in Bracebridge on Sunday the 13th of April. And I don't know, I might have to take the clippers to them before then, but this rest of the shag will get styled with at Classy Cuts here in Bracebridge. It's my pleasure to introduce our presenter today, Joanne Bolding. She is a lawyer and executive director of Lake Country Community Legal Clinic, and this is one of a number of legal clinics across Ontario. Um, this clinic serves residents in the districts of Muskoka and Parry Sound. And Joanne is no slouch to the legal profession. She has been a lawyer for over 25 years, and she's been here at the legal clinic as a staff lawyer and then as executive director for over 23 years. She's a graduate of Osgoode Law School, and she loves curling and participates. So was on the edge of her seat with all of the competitions going on in Sochi. And Halloween is her favorite holiday. You should see the costumes she gets up with. So it's my pleasure to turn this presentation over to Joanne. Thank you.
Thank you, Karen, and welcome everybody. This is a pleasure. This is new. I've usually attended webinars, so this is my first opportunity to actually assist in presenting one. So a couple of things. You don't have to read the slides. If you want to just listen to me talk, that's fine. You can the whole presentation will be archived, so you can watch it again later. But you also can always contact Karen directly, and she can get you a copy of the slides. So if you want the nitty-gritty information that is in the slides, you don't have to be writing instead of listening to me. You can just listen and get the information and then check back later. And as I'm going through, if you have any questions, ask them right then. You don't have to wait till the end. About halfway through, we're going to stop and do a few questions anyway, and then we'll finish the presentation after that. So as we said, this is about power of attorney, and obviously those are important documents for everybody, whether you're facing a health crisis or not. So I advise everybody to have power of attorney because they're very important documents in your planning for the things may go not your way. You may not be able to speak. So first of all, it's a legal document. It gives somebody the right to act on your behalf. The person is called an attorney. They do not have to be a lawyer. They have to be over the age of 18. They have to be competent, but they do not have to be a lawyer. Usually it's a family friend, a friend, a relative, you know. There are three types. Today we're only going to talk about two: continuing power of attorney for property and power of attorney for personal care. The first one we're going to talk about is power of attorney for property. This is about money. It's about your property. It's about your house. It's about real estate. It's about investments. It's about your bank accounts. And it permits the attorney to act for you if you're mentally incapable of managing your finances. But the important thing to remember about this document is you have to be competent when you sign it. You have to be mentally capable, but it takes effect the day you sign it unless you pick a different date. So if you're doing them when you're healthy, you generally pick a date, and it may be the attorney that you choose to decide whether you're capable, and maybe your family doctor, but somebody has to decide that you are no longer capable. But the important considerations is who you choose. And that is very, very important. Choose someone who you trust and is trustworthy. And that may sound funny, but it isn't. Go up to criminal court. Everybody that's facing and is convicted of criminal charges is somebody's family member. So you have to be careful about who you choose, and are they going to perform their role appropriately. The other thing to remember is to know your own information. Know what property you have, know what its value is, keep yourself in the loop, find out what decisions the attorney is making, make sure they run them past you, even if you aren't capable of disagreeing or agreeing. Ensure that you continue to get your bank statements, copies of investments and property still, so that you're getting duplicates. It's very, very important. This is your money. This is what you need to live on. And if it's not managed properly, it could decrease in value and mean that you have less money to live on. So choosing the effective date, and that's when you're planning your advanced care planning, is when in the future am I or a family member going to become incapable. And then not only, you can't pick a date, but what you can pick is who will decide. Many people pick their family doctor, especially if they've been going to the same doctor for 10, 20, 30 years. They know them the best, and they notice when their mental capacity starts to be reduced, and they start to make decisions that aren't making sense any longer. But you could choose your attorney, especially if it's a spouse. And also remember that as long as you are capable, you can change your power of attorney. You can either revoke it, which means to cancel it, and then presumably replace it with someone else. But like I said, you have to understand that if your attorney doesn't do their work properly, your property, your investments, they may decrease in value. You may also want to make sure that your attorney knows that it's a criminal offense to abuse the power of attorney. It isn't just a civil matter where you have to go to court and try and get your money back. It's actually a crime. The important thing also to remember is that incapacity is a legal definition. It's not a medical definition. It's as basic as, do you understand the facts and the context of your situation? And do you understand the repercussions of your decision? An example would be, perhaps you have $1,000 in your bank account, and your niece phones up and says, Auntie, I'm in trouble. Can you lend me $1,000? Well, you have to pay your mortgage that month, and your mortgage is $400, and you have 3 or 4 other bills, and they add up to about $600 in total. So in fact, you only have $400, and she wants the full 1,000. If you loan her the money and not are unaware of the fact that it will make your mortgage go into default, then you don't understand the repercussions. If you loan her the money and say, it's okay, I have an investment that comes free at the beginning of the month, and I'll use that to pay my own bills and lend her this money now, then it's clear. You understand your situation, you understand the repercussions that you need money to pay your own bills, and you have another way of doing that. So it's a legal definition. It's not hasn't anything to do with your health, though obviously your mental health may impact on it. And there are different definitions of incapacity. You may be incapable for one reason, but you may be capable for another. So you may still be able to give a power of attorney even if you aren't able to manage your money well. If you don't have a power of attorney, there are many agencies that will let informally somebody do it. Banks are not one of those agencies, though. And if you don't have one, I'm going to skip over a few slides, like I said, so don't worry about that. But if you don't have one, there are other ways of going to court or going to the public guardian to make sure that somebody looks after your money so that you aren't left destitute. Or left with it in a bank that you can't get at. And the next one I'm going to talk about is personal care. And the important thing about these powers of attorney is, first of all, I should clarify, a lot of people use the language living will. I hate that language as a lawyer because it's so inaccurate. You can't have a living will. A will takes over when you're dead, so it can't be living. But a power of attorney, both of them are about the quality of life while you are living. And that's what people are really talking about when they say a living will. It means they want to leave instructions while they're still capable so that they will be followed when they're not capable. And it is always about the quality of life to make sure that you have some say in your future when you aren't capable of saying it. And this is where power of attorney for personal care comes in, because this is about your day to day care, your medication, where you live, how you have clothing, how you have medical treatment, your safety, your hygiene. These are all really important things. And even though they're two separate documents, it can be the same attorney for both of them. If it isn't the same attorney, they clearly have to communicate, though, because you can't pay for housing and clothing if the attorney who's looking after the finances doesn't give the attorney who's looking after personal care the money. So even if they're not the same person, there clearly has to be communications and cooperation between the two of them. The other important thing to remember about personal care power of attorney is that it does not take effect when it's signed. It only takes effect when you have been deemed to be incapable. Now, we also call them substitute decision makers because in Ontario we have an act so that if you don't have a power of attorney, there is a list in the substitute decision maker in the act. At the first name on in the list, though, is the attorney, and then it goes down to spouses and children. But it's important to name your own. It's good to know that if you don't get around to it, there is a default that will look after you. But it is very important because if you have 3 children in the substitute decision makers list, they're all on the same. Well, if your children don't speak to each other, if they live very far away, they don't really know what's going on in your life, you may end up with them fighting with each other rather than caring for you. And you don't need that when you're in a crisis to have your children fighting with each other. But if you don't have a power of attorney, doctors will go to the substitute decision maker to ask for permission to do things. And that's the content of this document is as important as who you choose, because you need to let them know some of the choices they may be facing. So when my clients come to me, I suggest that they speak to their doctors, they speak to their family members, they speak, if they are a member of a faith community, they may want to go and speak to their vicar or whoever is the important person in their lives so that they can have their wishes respected. Now, they can't respect your wishes if they can't be met. Many people say they want to stay in their home until until they die. Well, that may not be possible if you can no longer walk and you can't get upstairs and the bathroom is on the 2nd floor. So even though you wish to stay in your home, your attorney may not be able to let you stay in your home because it's just not physically possible. But they certainly can, if you have the money, they can put in a lift so that you can move from the 1st floor to the 2nd floor. I'm just saying they may have to do a number of things in order to respect your wishes. And if they're medical wishes, you need to speak to your doctor because the attorney, you may say no extraordinary measures, but you need to know what extraordinary measures are. If you're a very healthy 45-year-old, then obviously if you have a heart attack, you want them to take extraordinary measures because if you're seen within 20 minutes, you have an 80% chance of survival or something. It's very high. Well, if you're 75 years old and you've had a quadruple heart bypass and you have a very serious liver ailment, you may have very different healthcare decisions that you want to make. And if you don't want your attorney to be figuring out what you need to do, then that's a conversation you need to have with your doctor and then repeat the conversation to your attorney afterwards so they understand the dilemmas that you're facing and where you would prefer, what decisions you would prefer. There are some things that the power of attorney for personal care cannot do. And one of the things is that it cannot decide that you have to go into a long-term care facility. That is something that you get to decide. And like I said, as with the other one, you want to make sure that the person who is doing the assessment of you, because with the power of attorney for personal care, um, if you don't name who is going to assess you, like your family doctor or the attorney, then it's going to be someone who's called a capacity assessor. Now, if you have money, that is actually going to cost you money in order to have that assessment done. So if you don't want to spend $1,000 on having somebody assess you, then you're going to have to name somebody whose opinion you respect to decide that you're not capable at that time. I hope everybody's able to hear me. I'm going to go back a few slides now and just talk about um, what kinds of decisions that you might be expecting someone to make. And with the continuing power of attorney, there's a couple of things that you need to know as well as what I've already said. The important thing is that they have power over your money, which means they can go into your bank account, they can sell your home, they can sell your investments. And as Karen's previous employment and something I'm still involved in is elder abuse. And while people mostly focus on physical abuse when you think of elder abuse, in fact, the financial elder abuse is much, much more rampant than you would think. So that's why I encourage people to make sure that they get a statement from their investments yearly, that they continue to get their bank statements, and that they continue to look and see what the money is being spent on. We find more and more children, nieces, nephews, whoever your heirs are once you become incapable, feel like it's their money. Even though you haven't died and it isn't yet in your estate, they feel like it's their money and they don't spend it on you. They spend it either on themselves or they don't spend it at all. And that's obviously very worrisome because they have control over everything. And that's why if you continue to get copies of your bank statements and your investment statements, you can see when money disappears. And it often happens actually in very tiny ways. One of the examples that we use a lot is it's the end of the month, your daughter's your power of attorney, and she gets a bill for her car insurance that she had totally forgotten about and didn't budget for. She's doing your banking that day, so she borrows the $800, meaning to pay it back, all well-meaning, not trying to cheat you or anything like that, but you don't notice. And a month or two goes by, and she just doesn't bother to pay it back. So next big bill that comes up, she does it again. And little by little, the money that you're expecting to keep your quality of life keep you in a state that you're used to is disappearing. And little by little, she's convinced herself that she hasn't done anything wrong, that if she had asked, you would have given it to her. But she's not asking anymore. And that's the important thing, is that she's not asking anymore. One of the other things that I suggest that the attorneys do is have a yearly meeting or a 6-month meeting, depending how complicated your financial affairs are, so that the family sits down and discusses it. Because one of the problems we have is that, as Karen will bring up in one of her questions, is who should the attorney be? It's not a way to keep your family happy. It's a way to keep your quality of life at what level you want. So if your children don't get along, don't appoint them together. They won't suddenly start getting along. I promise you. They really won't. And so instead of you being served, they're going to be fighting. If your daughter works in a bank and is incredibly good with numbers but can't stand the sight of blood or wouldn't change a diaper if her life depended on it, then I think it's obvious she's going to be the continuing power of attorney and someone else is going to be your attorney for personal care. Because if you're in a long-term care facility, you want your power of attorney for personal care to be going in there and asking, when is she getting her medication? How frequently is her diaper changed? Is she getting all the fluids she needs? It needs to be somebody that's prepared to ask you those kind of questions and then go and speak to the staff to pass along the concerns that you have. So if your nephew is the person who looks after you, that's who you should be appointing. If your son wants to do it but lives in Edmonton, just thank him very much and say, go away, son. I don't need you to do this because I need someone who's physically proximate, who can come to the long-term care facility or the retirement home or wherever it is you're living to make sure that you're being looked after appropriately. So it doesn't do any good for your son to want to do it if he's 3 provinces away, because it's just not going to happen. We all know that long-term care facilities, some are fabulous, like the Pines, and some may not be quite as good. And so it may very much depend on the power of it, the person who's coming in and saying what's going on with my aunt, what's going on with my sister, in order to make sure that you are being looked after properly. Having those meeting once a year with the money person is also a good way, if you haven't been looking at your bank balance, for them to show you a bit of a spreadsheet and show how they've been looking after everything. It doesn't mean because they're looking after you, your investments are going to increase. They still have to live with the market that they're dealing with. I'm not promising that they're going to increase, but at least they're not going to decrease because of lack of anyone looking after it or spending it on their new boat instead of making sure that your mortgage is paid down properly. So those are important considerations. Um, and the other important consideration is you may not have anyone. And this is a problem that I meet, unfortunately, all too often in my work, is that especially as people get older, they may not have anybody that's around, or their spouse may be as ill as they are, and it isn't a solution for them to be appointing each other. I don't have a magic bullet for that. I really don't. There is the Office of the Public Guardian and Trustee, and it is the very bottom name on the substitute decision maker. But they manage money fine. They pay the bills. They file the taxes. They're very, very good at managing money. Um, they're very reluctant, and it's very difficult to get them to be the power of attorney for personal care, even though they are supposed to, according to the statute. Trying to get them to do it is a very difficult thing. But if you don't have anybody, don't just take the neighbor next door who's been bugging you to buy your property for years anyway. You need to be able to pick somebody who will look out for you, not look out for them, but to look out for you. But like I said, you could have a statutory guardianship, and that would be the Office of the Public Guardian and Trustee. And they would certainly look after any of the decisions that you need to be made on your behalf as far as money goes. Um, uh, the other thing that I also tell people is this isn't a secret, people. If you've done power of attorney, you need to share them with people. Other members of the family need to know. Your doctor needs to know. You need to put that little card in your wallet or your purse, so that if you have appointed an attorney, they're the ones that are contacted. Because we know if you're in a car accident, we get rushed to the hospital, the doctors immediately are going to try and stabilize you. And then at that point, they'll look in your wallet to see if there's someone they can be contacting. If they don't find anybody, they're going to try and find a family member. It may or may not be the person you want to be making the decisions. So make sure you share the information with everybody. If you change your power of attorney and revoke it, then you need to make sure you get all those old ones back and give them the new one, because that is also a problem. If somebody's working with an out-of-date power of attorney, then the wrong person may be contacted and may make decisions at a time that you don't want them to be making the decisions. So I think that's sort of covered most things. I know Karen has some frequently asked questions that she's going to bring out. And if anyone else has any questions, please feel free to type them in. We'll sit close.
Yeah, actually, it doesn't really matter. One thing that I haven't experienced it myself, but I did see it or heard from someone else. They went to their bank and wanted to execute something, and the bank insisted that they fill out a power of attorney form that was specifically for the bank. And I understand there's some complications, can be some complications with that.
Absolutely, and we've done some work with banks, and some of them are getting better at it than others. But the trouble with that is when you assign a new power of attorney, you will have invalidated the previous powers of attorney. But all of your investments, your mortgage, your bank accounts may be at different banks. They may not all be at the one bank that's handing you the power of attorney. And so it will be quite a small restrictive power of attorney, and that's not what you want. So most banks now are getting much better at that. When you bring in your own power of attorney that you've done, they make a copy. It goes down to their legal department, who checks it over to make sure that it's done properly, because there are some technical things that need to be done that I'll go into after this question. So there are no, many banks have stopped doing that. But just 2 weeks ago, I was out for lunch with a woman who partner at Padden and York, and she went up to a bank in Parry Sound, and the bank manager and had the same discussion, where she said to her, no, if you hand that power of attorney to somebody, you could actually be harming the power of attorneys they already have signed. So be very careful if a long-term care facility wants you to sign a power of attorney, or a bank wants you to sign a power of attorney. Don't do it. Sign the larger ones and provide them with a copy, because all they really want to know is who the attorney is. It's not that they're really attached to their own forms as much as they want to make sure you have one. And you could see why they want to make sure, because when your nephew comes in and starts managing your bank account, they want to already have on file that he's allowed to do that, because they have seen a copy of your power of attorney. And the same in the long-term care facility. If something were to happen, you were to fall, they want to know who they need to contact. So it's really the content. They really want to know who the attorney is. So it's easy enough for you to say, no, I don't want to use your forms. I have one of my own, and take it in. When my clients leave here, they often have 7 or 8 certified copies of their powers, so that they can hand them to banks and doctors and family members, so that there is no confusion and that everybody is clear on who it is. Like I said, there are a few technical things, and those slides seems to have disappeared. I don't know what happened to them. But there's the list on slide 34. If you don't have a power of attorney, there's the list of the order in priority. So if the Consent and Capacity Board has appointed a rep, they come first after, like I said, power of attorney, it isn't one. Your spouse or partner, your child, and even though it says child, it's all children and they're on the same level. There is no priority given by age or sex or anything. Your children all have an equal voice. Same with your parent, your brother, your sister. Then it goes to any other relative. And like I said, finally, at the very bottom is the PGT. There are some technical, oh yeah, let's talk about multiple powers, multiple attorneys, because that is one that I get the most questions about. Yes, you can appoint more than one attorney, but you must remember that if the attorneys are to work together, which is jointly and severally, they actually have to be able to do that. And if your 2 children have never gotten along, they're not going to start getting along when it comes to talking about money or personal care. So you have to be very careful. And I've had a number of people say to me, oh, but my son would be so upset if I didn't appoint him the attorney. It's not about him. It's about you. It's about making sure that your decisions are respected and put into place. And if your son is not the appropriate person, then you just have to explain that to him and hope that he's big enough that he will get over whatever disappointment. It's not an easy thing to be an attorney. There's actually a fair bit of work and responsibility attached to it. So if your son is going through a divorce, or your daughter is struggling with some addiction issues, this is probably not the time to ask them to take on these other duties, and to ask them to take them on together when they haven't even seen each other for a couple of years would just, I mean, you're asking for a disaster, and it's not a good thing. As I said, the attorney must be 18 years of age or older, and they must themselves be capable. You should also always list an alternate. Your attorney may be out of the country on vacation when a crisis happens, or they may themselves be going through a health crisis, so that they are unable to act and so decline, even though they agreed when you asked them, when you executed the document 4 years ago, they may be going through something. So it's always good to have an alternative, because if you don't have an alternative and your attorney can no longer, or decides they can no longer act, then it means that you're to the public, you're onto that list. And if you don't have any family members, you're at the public guardian and trustee. And these are the nuts and bolts of it. You must have two witnesses sign the document, and the witnesses can't be related to you. They can't be your spouse, partner, child, or someone you treat as a child. They can't be the attorney or the attorney's spouse or partner. They must be over the age of 18, and they cannot be, they can themselves cannot be under a guardianship, because if they're under a guardianship, they're incapable, so they can't be a witness. So that's really important. And then there's some definitions I've given to you. A spouse is a person you're married to. You've lived common law with for at least 1 year. This is different from other legislation. You have a written cohabitation agreement, or you have a child together. So they're very clear on what a spouse is. And a partner is if you live together for at least a year, or you have a close personal relationship of primary importance to the both of you. So that one's a little bit self-defined. And that's how to revoke it. And again, revoking should be witnessed, and it's the same rules as the other witnessing. There's no form. Unlike the powers of attorney, we have the booklets here. You can get them at your MP's office, or you can contact the public guardian and trustee and get some copies from them. And there's actually a form, but there's no form for the revocation. You just write down that you've revoked it. And it's, like I said, it's really important to give a copy to everybody who you gave the original one to, because you don't, if the attorney has declined being able to act because they themselves are sick, you don't want them getting calls, because that would be very upsetting to them. And as I said at the beginning about living wills, power of attorney ends when you die. They don't get to use it to make the funeral arrangements, to get into your bank account and pay the bills. Once it ends, once you die, it ends. At that point, if you have a will, it takes over. And if you don't have a will, then you go to the legislation that decides how your estate will be managed. It also ends if your attorney dies. Seems obvious, but I thought I'd say it anyway. Or when your attorney becomes incapable or resigns. And again, as I say in brackets, if the attorney resigns and you have named a substitute, then the document is still valid. The substitute just steps in. And it also ends if the court appoints a guardian. And that happens when somebody feels that your attorney has abused their a power of attorney, and you're incapable of appointing a new one. They go to court, and the court appoints somebody for you. So if the court's appointing a guardian that's wiping out a power of attorney, it means, quite frankly, the power of attorney has not been an effective document. It also ends when you sign a new one, and that's going back to what Karen and I were talking about. When the bank gives you quite a restrictive one, it may end all the work you've done on the other one. So, and because they're pre-printed forms, you can't put in the bank one that it doesn't revoke the other ones, because it's on a form. And obviously it also ends when you revoke it. That's the other way it ends. And as I said, remember to keep a copy for yourself. And I don't think you have to carry them with you, but I really do think it's important that you have the card in your purse or your envelope, so that you know, if you're in trouble and you aren't able to speak, maybe you're in a coma, or have been given medication and so are, you know, not able to read and kind of stumbling at the moment because of the strong medication you're in, then they can just go to your purse or your wallet. Um, Substitute decision makers are people that get to make decisions if you don't have a power of attorney, and they can make decisions about health treatment, admission to long-term care, and personal assistance while you're in long-term care. So it's really important for you to know what it is that you can get done and what it is you can't. And there are some restrictions on who you can name. And you can see some of these are aimed very much at combating elder abuse. If someone is paid to give you health care, social, residential, training support, unless it's your partner or your spouse, they cannot be your attorney. And that's obviously to prevent abuses from paid helpers, which has been an issue in previous years. And again, you can't name someone under the age of 16, and you can't name anyone who's mentally incapable themselves. And that's one thing an attorney absolutely cannot do. They cannot sign a power of attorney for you. And I've actually had that be done, and it ended up being in front of the Law Society because you can't do that. There are restrictive rights, and one of the things they can't do is sign another power of attorney for you. And recently there was a very big case in the news, Brazuli case, and it was about a gentleman who had gone in for brain surgery and had a catastrophic brain bleed later. And the doctors wanted to shut the machines off because, in their medical opinion, there was no brain activity. His wife, who was his substitute decision maker, refused to allow them to do that because both for religious reasons as well as discussions her and her husband had had prior to the surgery. She said that he would not have wanted the machines shut off. He would have wanted to continue to try and recover. We're talking a few years here. We're not talking a number of months. And instead of going to the Consent and Capacity Board, the doctors made her sue them in court. So she had to go to court and get an injunction to stop them from shutting the machines off. The case went all the way to the Supreme Court of Canada, and the Supreme Court of Canada said Ontario has a regime. If the doctors disagree with the attorney's decision, which was to keep the machines on, then they have to go to the Consent and Capacity Board, and they are the ones who will make the decisions whether the patient's wishes are to be honored or whether the doctor's medical position is the one to rule the day. I don't know if they ever went to that board after the court case, but it brings out the importance of having these documents so that it is your attorney's opinions that's listened to. They can listen to the doctors and agree with them or disagree with them, but it's up to them to make the decision. And that's what's really important about that court case. I see we have a question here from Ray. Is it a big issue if someone cannot make decisions for themselves for a while due to meds or whatever reason, then recovers and is able to make decisions later? No, it's not a problem. You're absolutely right. With the personal care document, you can come in and out of it. And when you're capable, then you get to make the decisions. And if the attorney says you're not capable and you think you are, you go to the Consent and Capacity Board, and they will decide which of you gets to make the decision if your attorney disagrees with you. With the continuing power of attorney, the money one, it's a little more difficult because you choose when it takes effect. So it's a little more difficult once you've handed over your finances to someone to then take them back again. But the way to do it is to either pay the money to be assessed, and if you're found capable, then you can revoke the power of attorney and take control of your life again. And if they say that you're not capable, then you are stuck with what the documents say. Does that answer your question, Ray? I know I can't see you, so you can't nod, but if you could type yes, no, need more information, that would be great. Okay, great. Thanks, Ray. That was a good question because with many conditions, like Parkinson's, like cancer, like various of the conditions that HIV and AIDS get, where people are healthy and then unhealthy and then healthy again. and the medications that people are on are really, they are wonder drugs, but they have incredible side effects. So you're right, it can be a difficult thing, but you do have the backup of being assessed or going to the consent and capacity board if you decide that you're capable and your attorney thinks that you're not. Karen, do you have any more questions?
Well, Joanne, you mentioned that you would answer questions about other things, and I remember one presentation that you did. We were talking about wills and how some families are wanting to avoid probate by putting
Joint bank accounts.
yes, and adding their adult children's name to their property and things like that. And if you could just maybe talk about some of the implications.
Bad ideas, generally speaking. Before you make any of those joint decisions, you need to really think very carefully, because it's open season on your money once you've done that. And I mean that quite literally. If you put your daughter on your bank accounts and then you decide to be fair, you're going to put your son on the deed to your house, and your son is sued, he can lose your house in paying off his debts. That's how drastic it can mean to you. It can mean you will lose everything. So in order to avoid some estate taxes, you may end up with nothing. So my advice is, if you have those kinds of thoughts, go and speak to your lawyer and your accountant or your banker. Bankers are good on this because they hate joint bank accounts with a passion. Because it probably isn't worth what you think you're saving. The risk to you is very high. If they've been sued in small claims court and there's a garnishment out, your bank account becomes your daughter's bank account, and that goes to pay off that debt. And that's just the end of it. So joint bank accounts are very, very dangerous. They become the account holder. It opens you up to all sorts of liabilities that you should think very seriously about. Yes, I know it is inconvenient, and banks don't want you sharing your PIN, your ATM cards and everything. And when you're incapacitated and you can't get out of the house and you need somebody to run errands for you, it is very easy to hand over your card and say, here's my number, just go get $100 and run off and do all these things for me. And I understand that. I've done it myself, though I don't tell my banker that I do it because it's illegal. In fact, in the form that you sign at the bank in order to get that card, you promise never to share it with anyone. But we all do it for good reasons. But then what you should do afterward is contact your bank and get your PIN number changed, so that the next time they come, they have to ask for your card again. They can't just go into your wallet or your purse, go and run the errands without you knowing what's going on. And if somebody does run your errands, then get them to bring back receipts. I mean, it's as simple as that. Pay attention to your money, and your money will be better cared for. But joint bank accounts and putting your children on your property is just a recipe for disaster. And if you really do feel that you have to do it, then you need to sit down and have very frank discussions with them. And you want to see all of their banking records. You want to see all of their information to know that they're not being sued, to know that they don't have debts that are going to be recovered from your estate before you've passed it on to them. Speak to a lawyer, quite frankly, is my best advice on that, Karen.
Mm-hmm.
Anyone else have any questions? No one's typing at the moment. Okay, so one of the other things that I'm going to give a plug for is, I mentioned it briefly, is family councils. They're really, really important that you and your family get together and talk about these issues honestly and frankly. Some of the issues may be very personal, depending on the stage you are in a disease, but by not speaking about them is when we we get people phoning us up and saying, I know George is abusing that. I just know he is. Every time I go there, he seems to have a new toy. He's got a new boat. He's got this. And we have all this hatred kind of fomenting, and nobody's stopping it. And whereas if you sat down and had family councils, and George could tell you that, as foolish as it is, he took out a loan to buy that gorgeous boat, that he didn't spend mom's money on it, then the family may be able to get along a little better. But with all this suspicion that every time something good goes on in their life, they must be spending mom's money. And family councils, I find, is a way to prevent that. Have a barbecue, have everybody there, sit down with your papers, have a meeting, and then have a family dinner afterwards, so that people understand that you made the choices that you made for who your attorneys are, and that, as well as reporting to you, they're reporting to everybody, so that everybody knows that everything is being done appropriately. It's not required by law. It's just one of those practical things that makes families work better if we spend a little bit of effort in making sure that everybody knows what the documents say and how, in fact, they are being treated by the people doing them. Because the vast majority of people, of course, are very careful and keep records and make sure they're doing everything properly. But if the other family members don't know that, they still are suspicious. That new fridge, that new stove, that vacation that somebody could take when they know they couldn't afford a vacation. It's important information to share.
And it's really about communication, isn't it? And I think a number of the previous speakers in this webinar series, we've talked about communication, and sometimes, it's getting over that hurdle of telling someone that I've got Parkinson's, and the fear and the embarrassment and all of that you might have, and once you share it, it's like a burden off your shoulders, and communicating that with your friends and your family members, and especially with your spouse. And once you can say some of those words, it frees up so much of the stress that you have.
Well, and there's also a lot of misconceptions about Parkinson. And your children or your nieces and nephews, whoever your intimate family members are, may have a lot of those wrong notions. And so they may assume, as soon as you have a diagnosis like that you're not capable of doing anything. And so they want to start telling you how to live, and you don't know why they're suddenly thinking they should tell you how to live. So communication is really very, very important, because we have so much easy access to popular culture, and a lot of it is crap. A lot of it is misinformed. I don't know how you feel about it, but all of this stuff around, people getting their shots and inoculations, and how bad they are. And so now we have diseases that we had practically eradicated coming back in industrialized countries because of misinformation about science. And Parkinson faces the same thing, that many diseases that are hidden. Just because you have the shakes doesn't mean you have Parkinson's, and it doesn't mean that's your only symptom or crisis that you're facing.
Or that it's debilitating.
And that you have no capacity as soon as you have that diagnosis. And obviously there's a number of conditions that the same kind of fear immediately comes into it. Is it catchy? Nobody wants to be near you anymore. Are you capable? You're going to need so much help, and people don't want to be the ones helping you. So open communication really does make a difference. And in advanced care planning, it doesn't work if the other people don't know what you're advanced care planning about.
Wonderful.
I think we're kind of done. Do all of you know Karen's email address, so that if you want a copy of the slides, you can order them from her?
Probably.
I don't know how to give that information out. Oh, thank you, Nora.
Nora Lee. Oh, great. Wonderful.
Can I type? I can. What's your email?
Karen.Blair @Parkinson
So I've typed it on the screen. I hope everybody can see it. But if you would like a copy of the actual slides, Karen can arrange that for you if you just send her an email.
Wonderful. Joanne, thank you very, very much.
Thank you. This was pretty painless.
I have to tell you when I snagged Joanne to come and speak to different support groups in Muskoka, and she brings this wonderful roulette wheel, and at the end of her presentation, we spin the wheel, and she has questions, and if you get the right answer, you get some chocolates. Big bribeage up here in Muskoka.
That's right.
It's lots of fun. She makes understanding some of these what can be complicated and technical issues very understandable and fun. So, Joanne, thank you very, very much.
And on Halloween, I wear my witch's hat. And you're quite welcome. And at the very end of the slides, I don't know where people are from, but there is our 1-800 number. If I've raised some questions and you need someone in your own community, a referral, or if you're in our community, there's our 1-800 number. Feel free to give me a call. And like I said, when I suggested you go to a lawyer, if you don't have a lawyer, they're all listed in the yellow pages of the phone book, whatever community you live in. Or if you call the Law Society, they will give you a referral to a lawyer who specializes in estates and wills. And that's the category of lawyer you're looking for when we're talking about powers of attorney.
Right. Wonderful. Thank you.
Thank you. I don't know how to get out of here now.
Well, I'm just going to finish off by letting you know that our next webinar is on Tuesday, May the 6th at 1:30. And our presenter will be Sherry Waldock. She has her master's degree in social work and has a lot of experience working with family health teams. And right now she is with the seniors assessment outreach team here in Muskoka. And she works with her clients, helping them find resources in the community and helping them be advocates for themselves. So she will have lots of tips next month when you join us. And thank you very much. See you next month.
Bye, everybody.